Good evening. We're live here from Houston, Texas, every Tuesday at 5 p.m. Central Time. We're bringing immigration law updates live from Houston, Texas. Emily, what do we have today to discuss?
All right, today we wanted to talk about issues that come up if your passport is expiring soon. How does that impact your filing of extension applications with USCIS? How does that impact visa stamping? What to worry about if you're traveling using that passport? And also, obviously, with the visa bulletin coming out for December and dates not moving again for EB2, EB3, it doesn't look like it's going to be moving anytime soon. What are some of the alternative options that people might have in order to get the green card faster? And we're seeing a lot of issues lately with situations where the employee is having to deal now with fraud that was on the part of the employer several years ago. And how that is impacting them since that happened, even though it's the employer that was involved in it and not the employee. What's the impact on the green card and in the long run? Lastly, a lot of questions right now about people that are starting the green card process or a certain way into the process and are now being offered a promotion, and they want to be able to take that promotion, and many of them are being told, oh, well, you'll have to start your green card process all over again. Is that really true? What are the options there?
And first, I want to discuss about the passport expiry. This comes up as a very common question, especially when I do conduct the daily free conference call that our Reddy Neumann PC conducts. A lot of people use it. If you don't know what about it is, the link is provided there. You can come there. It's free. Every single day we conduct live. I will be answering those questions, and sometimes it's my business partner, Rebecca, will be there. Emily, a lot of the countries, though, will not allow passport extensions unless it is within 1 year that is expiring. A lot of the people have concerns. Let's address one at a time, Emily. So let's say, for example, I'm going to H-1B visa. Let's address visa stamping. Let's say I'm going for visa stamping for H-1B. My passport is only valid for 6 months. Can I get a 3-year passport stamping on H-1B or H-4?
So generally, the rule is that your passport should be valid for 6 months beyond the intended stay in the U.S. So if you're applying for an H-1B visa, you've got a 3-year stay on your I-129 petition, your passport should be valid for 3 years plus 6 months. However, there is a list of countries that rule does not apply to. India is one of them. And so the 6-month rule does not apply. So you can actually go for stamping with a passport that's expiring sooner than that and still get the stamp.
Not only it's just India, there are 134 other countries that are exempt. It's a very laundry list of countries. Just the A, if I keep on reading A, it's going to be so long of those countries that are exempt though. Most of the countries. So it's not a big problem at the passport stamping, Emily, right? Do you see any issues there at the passport stamping?
Right.
So even if my passport is expiring in 9 months and I'm applying for 3 years, H-1B or H-4 or B-2 or F-1, it's not a problem. Now, what about when I come into United States? Of course, for the F-1, they give duration of status, especially for the H-4 and H-1. Do they give 3 years? Let's say, for example, I applied in 2022 November. I got my H-1B and my wife got it until 2025. When I enter the United States, do they give an I-94 until 3 years, or they will only cut it out until the passport expiry date?
Yeah, this is where the biggest impact is. They will only give you an I-94 valid till the day your passport is expiring, not the day your visa stamp or your I-797 is expiring. A lot of people are not aware of this. And so when you're coming in thinking you're going to get a 3-year I-94 that matches your H-1B approval notice, and you only get a 2-year I-94 because your passport is expiring in 2 years, some people don't even notice it, especially now with I-94s being online. A lot of people don't know to go online and get it. And so that if you actually overstay that shortened I-94, that is considered an overstay, and it could have very severe consequences. So if you even though you're able to get the stamp in your passport with a passport that's expiring before the visa will expire, when you're entering, CBP will cut short your stay, cut short your I-94. So you have to be aware of that so that you can properly extend your H-1B after you get the passport renewed. Is it the same if I'm filing an extension with USCIS? Let's say I'm already here, my H-1B is getting ready to expire in the next 4 months.
No, Emily.
Even if my passport is expiring in like 2 months, I can still file?
You can still file for 3 years of extension. Let's say, for example, your I-94 your H4 is expiring in February of 2023, and your passport is expiring in December of, I'm sorry, let's say January of 2023. You can still file the extension. The passport has to be valid on the day you file the extension. It doesn't have to be valid until you request. It doesn't have to be even valid from the time you're requesting the extension too. You can always extend the passport later on. It's not a big deal at all. One addition that I want to add, Emily, is that when people are entering into the United States, you said it's the biggest problem. In fact, this is the most common reason that I see Indians go into unlawful status. Unfortunately, it can be easily avoided. There are two different ways it can be avoided. The first thing is that you need to notice the I-94 online, as Emily has pointed out. The second thing, there are two corrective things that can be done. Either you can go to Mexico or you can go to India and come back, or you can even file an extension. This is the most common reason where we see Indians getting into unlawful status from our office, which can be easily avoided. Just notice it, contact a lawyer. It's so easily extendable. Coming to the point of port of entry we addressed is extension visa stamping. There's another problem that comes out, Emily. I have my passport visa stamped until 2025, and now I have extended my passport. Can I travel because the passport visa is on the old passport? I have a new passport.
Mm-hmm. Yeah, the good news is yes, you can travel with both passports. The visa, they'll put a little note, visa in other passport, or visa VOOP or something like that, a little notation on there. So you can still travel with the old passport with the visa stamp and the new passport with the extended validity.
We never had any problem when the people have a new passports. They're traveling on the old passport visa. Has never been a problem at all. Anything else we can address before we go to the EB2?
I think we can go on to the next. So obviously with EB2 and EB3 dates not moving, EB1 is probably one of the biggest question people are asking us right now. How can I get into EB1 where the dates are current? There are three different categories of EB1. EB1A, EB1B, and EB1C. I'll start with EB1C because this one actually requires you to go outside the US if you have a company that has locations everywhere globally, a multinational company that files L1 visas. This may be an option for you if the company is willing. They can move you to one of their other locations outside the US in a managerial or executive position. You work there for 1 year, and then they can bring you back into the US either on a new L1, which you would now qualify for if you're coming to work as a manager or executive, or even on an H1 that you had previously, if it's for the right position and it hasn't expired while you've been outside the US. At that point, you become eligible for EB1C, which is for multinational managers and executives of global companies. So the company can then file a new I-140 petition for you. You can actually port the priority date from your EB2 or EB3 into EB1, which generally you wouldn't need since EB1's current anyways. So then you can file your 485 along with that. So that's kind of one option, but it's very drastic because it requires you to move again for an entire year. And it also you need to be aware that not every manager position is a manager position in the eyes of USCIS. So you definitely want to have someone review the position that you're going to take outside the US for 1 year to make sure it qualifies, so you don't end up wasting a year coming back and then not qualifying.
You may also want to consider the EB1A option, which requires extraordinary ability. And EB1B is morely like outstanding researchers that you must be working in a research field though. But EB1A can be considered too. Recently there have been rumors and there have been some acquisitions which people are telling that EB1 has been abused very much. And because of that reason, the EB1 is using the entire quota that has been allocated to them. And thus by no spillovers to EB2. I may want to disagree with them because in the Trump era, we have seen EB1 getting denied, very large number percentage of it. We have seen a very good percentage of EB1A getting approved, EB1Bs. Normally, the requirement is that you must work for a research organization and you must be in a research field and you must be qualified. And EB1B has always been very easy as long as the company is qualified and the individual is qualified. But now we have seen a bump in the approvals of the EB1As and EB1Cs. As Emily has pointed out, not everybody may be counted as a manager according to the eyes of the USCIS, but looking into the interpretation of the USCIS in the Trump administration as compared to the Biden administration, we have seen a very big bump in the EB1C category though, and very big bump into EB1A category. It may be worth, I want you to Google it out with regards to, we have made a separate video with regards to the EB1A. You can look into it to see if you may qualify. EB1C is you have to go outside the country. That means that you have to approve the entire family and then you have to go outside the country, work there and come back. EB1A is completely different. If you're qualified, you can just file it and convert your EB2 into EB3. So you may want to look into EB1A option and EB1C option and EB1B if you're qualified as a researcher. One caveat that comes in is that people ask me, what about EB5? You could consider EB5 too, but we want to be very cautious on EB5 because the people who are selling you EB5 have a vested interest. They want to get you $1 million, simply. The limit previously was $500,000 minimum. It has gone all the way to $800, $900 right now for the minimum investment. They want to get your money, so be very careful though. I want you to go to online and search the processing times of I-529, is right? I-529. That's for the, it's very similar to the I-140. The processing time is about 46 months. Until that is approved, your green card is not going to be approved though. You have people walking into it, hey, you're going to get an EAD pretty soon. Especially under the new version of the USCIS where you can parallelly without the I-512 getting approved, you can still file the 485 right now. You can get an EAD. You will get, if everything goes through very good, you will get a green card somewhere in 4 years. It's not immediately you're going to get a green card. It will take 4 years because the underlying application has to be approved before your 485 can be approved. Now here comes the big question. Is the green card is approved, are you free, Emily, once they get the green card, or they don't do anything else?
No, you're not free yet because that green card.
How come I'm free when I get an EB2, EB3, and EB1 green card?
Right. EB1, 2, and 3 is a permanent green card, unrestricted. No further thing has to be done. You can just apply for citizenship when you qualify. But EB5 is a conditional green card. It's only valid for 2 years. You have to file another application to remove the conditions to get the permanent green card. And that application processing time is another 4 to 5 years. So although you may be getting the green card faster in 4 to 5 years, you're still not getting a permanent green card. It's another 4 to 5 years, so a total of 10 years to finally get that EB5 permanent green card. And you've got money tied up in that. You may lose your investment, so just be very careful of that if you're looking at EB5 as another option.
One other thing you may want to consider other option is Canada, Canadian green card. Can I do Canadian green card option? Yeah, you may want to consider that option too. To have an option to, if you don't want to go back to India, especially things will change. The economy will change. It will go up and down. But speaking about green card application in many, many decades though, things will not remain the same. Do you want to have an option, to have a backup option, to have a green card of Canada? You may consider it. Our office will not be able to help it out, please. We're just giving an option to you. It doesn't mean that we will help you out. We have never done any Canadian green cards. We're not even eligible for it. So please, that option, you can look into it. You may consider it. If I were you, I would definitely consider it. Another thing is that if the economy goes down, where you get laid off, what will happen? What will happen to your priority date? What will happen to the H-1B? Especially if you have an I-140 approved, guys. You can always go to India and come back when the circumstances come back better. And if you have been counted toward the H-1B number, if you have an I-140 approval for more than 6 months though, I mean, for the next 90 years, you don't need to be counted toward the H-1B number. That means that you can always circumvent the lottery system and come back into the United States to the consular processing. Why would I say 90 years? The reason people keep on telling it's 1 year, 2 years, 90. The reason here, one simple reason is that I do not expect that you will live longer than 90 years from now. That's the reason I say 90 years. People will ask, can I come back after 1 year? Can I come back after 2 years, 3 years, 4 years, 5 years, 6 years, 7 years? Is there a limit? No, 90 years is the limit. You can come back at any point of time within the next 90 years on H-1B without subject to the lottery system and come into the United States. And you can still use the old priority date. So if you have a priority date of 2018, 19, let's say things go down and then economy goes down, you don't have a H-1B job, you go to India, you can always come back at any point of time. You may want to consider that option too. H-4 EAD is another option if you don't have a job. F-1 is another option. But going to India probably is another option too.
Yeah, and let me just clarify, there is no 90-year rule. There's no 90-year limit. That's based on, you can always get the H-1B extended beyond your 6-year limit because you have an approved I-140 as long as your priority date is not current. So we're assuming your priority date won't be current in the next 90 years, maybe even longer depending on your priority date. That's where the 90 years is coming from. But once your priority date becomes current, if you're not already back in the U.S. on H-1B, then it gets tough because you can only get a 1-year H-1B, and you've got to get
instead of 3 years, they'll get 1 year.
You've got to get a new labor, new I-140 approved during that 1 year with the new company. So if you're going to move back to your home country and wait it out, keep an eye on the visa bulletin so that before your final action date becomes current, you've made plans to get back to the U.S. in H-1B status.
And we see a lot of times when people are in the lottery system, when they will apply for multiple companies, especially the companies that are not working. And previously, to apply an application, they have to pay the legal fees, they have to pay the filing fees. And if it gets selected, the entire money will be gone. So we didn't used to have a lot of these fake companies coming into picture. In the past 2-3 years, we have seen that because it's only $10, who cares $10 right now? So all the people are flocking. This is my last time I need to get H-1B. So they apply for multiple companies. And you know these kind of companies that they operate and then they leave the country and then go when there is an investigation. And our guys will get a H-1B from that company and then they will move on to a different company. Do you see any problem in that?
Definitely. We see this come up not any time in the close future or the time period right around when you got that approval. It comes up 3 years later, 6 years later, 10 years later. So you may have already transferred to another company, filed multiple extensions, but we see this oftentimes coming up after 3 years into the 3 to 6 year range when someone's going for visa stamping. The visa interview goes into this. They'll get a 221G. Their visa is put on hold for months and months and months. That's quite common. We see people grilled at the port of entry when they're coming back, if they do get the visa, about these companies that filed these kind of cases, wanting to know, did you pay this company for submitting your case into the lottery? Did you pay the $10 fee? Did you pay the company, there's some companies that were providing fake end client letters and that sort of thing. Were you involved in that? Did you submit that letter to the consulate and those sorts of things? Even beyond that, even if you never get a notice of intent to revoke or things like that on the petition where they're not saying you did anything fraudulently, they're talking about the employer, we're seeing it even coming up in advanced parole applications.
That's surprising to me, recently.
This is, 10 years later, you've got your 485 pending, you file the advanced parole like everybody does because it's free, and you get a denial, an automatic denial, no RFE or anything, of the advanced parole saying, we think you're inadmissible, therefore we're denying your advanced parole. Well, that's a pretty big statement for them to say, we think you're inadmissible. Inadmissible means you're not eligible for the green card. So that's something, again, that what we've figured out as we're digging into these further, a lot of times it's tied to an old revocation of an H-1B from one of these fake companies.
Yeah, be careful. Don't fall into the trap of these people, guys. Look into the long term. Don't look into the short term. If needed, just move on to the F1 visa, or if you have a H4 EAD option, or even if you have to go back to India and come back, please look into those options. Don't fall into the trap of these people. They will escape to India. The USCIS and the FBI is not going to go after them in India in their particular village in Guntur, Warangal, or whatever their places, and drag them out. Even if that happens, what benefit you're going to get? you're not going to get any benefit. You'll still be stuck in the process. Emily, we see all these FANG companies. What do you call FANG? Facebook, Apple, what is it? Google.
Netflix.
Yeah, whatever. Yeah. Now FANG, what? No,
Alphabet.
it's Meta. It's Alphabet. It's Meta.
Yeah, I guess it's Mang now.
Meta now. Yeah, Mang now. A lot of these companies, when we see that, when they get promoted from a lower level position to a middle level, higher level position, they don't keep on refiling the perm applications though. And even that seems to be our office practice from the beginning though. Why do we see some of these companies that say that every time you move to a different position, higher level position, you have to file a labor certification again? Which one is true?
Yeah, I disagree that you have to start the whole process over again. I think you have to look at the job itself, the original job and the new job, and determine, is there a material change in the job duties that would potentially cause a different wage to be assigned, either because it's a different SOC code or because it's a different wage level. Is there something that's changed in the job that would have now U.S. workers would be more likely to apply for it with this new job compared to what they would have in the old job? And I think a lot of times promotions don't fall into that, where it's not really a material change. So many times I talk to people and they say, I'm really doing the exact same job, just my title changed. I got a little bit of a pay increase. Why is my attorney telling me I have to file this whole thing over again? We disagree with that. I think that is being extremely conservative, and it's really a waste of resources of the company as well as government resources, with them having to re-adjudicate these prevailing wages again and again, the perm again and again, I-140 again and again. We know USCIS recognizes that career progression happens. They can't look at this, a snapshot of your career when this process is taking months and years to go through.
Years.
Yeah.
Would you correct the sentence you said in the decades?
Oh, for sure. But, if we're talking about someone who has their prevailing wage pending and now they, heard from their manager, we want to promote you, and they're thinking, oh, well, I'm going to have to start over again on my prevailing wage. I've already wasted 7 months. Should I just not take the promotion so I can get my perm filed? Especially if you're near the 6-year limit, you've got to think about those things. But in many, many cases, it is not necessary to start anything over again. I don't.
So what if the scenario where I come across where, a lot of these bigger companies and good lawyers like us say that we don't need to file a labor certification again. It's a natural promotion, and we have never faced any trouble at all in the thousands and thousands of people. And then, yes, thousands of people are watching us on the YouTube, in our TVS and other shows. We don't face any problem in them getting the green card, though. Why some of these companies or the lawyers are telling they need to refile the entire permanent I-140 when there is a little promotion?
Yeah, I think it comes down to legal fees. You can milk that company for more money by being super conservative and telling them you've got to start over again. Now you're gonna have to pay me again to do this process.
And let's assume the other thing, Emily, that okay, I apply for my labor certification in 2016, and based on based on some of the readings, it may take 10 years, 20 years to get a green card. What kind of person will be working in the same position for 20 years? And if that person is working in the same position for 20 years and with the same job duties, same everything, can that not be fired? If Reddy Neumann PC will definitely fire. If the person is working on the same thing for the next 20 years, not improving, and then every time they are improving, that means that you have to file a labor certification. That is ridiculous. I don't think so that's legal at all what they are doing. I think so it's illegal, or I know you call it a conservative. I think so it's just cheating the clients is illegal. That's the way I take it as. You may want to consider suggesting your company to hire a different law firm. Look into the companies, Facebook, Google, Apple, Microsoft, Tesla. They don't do that. Why only this particular financial companies or some bank companies? These are the mediocre companies. They don't hire that many IT people anyway. These are the companies insurance companies, these are the only companies that I see that sometimes requires for a higher level position, they need to file. I suggest that they need to change their lawyer. You need to recommend them. And if needed, contact our office. We'll do a free service if you give an appointment with your HR, we will explain it to them. We won't even charge you any money as long as the company is a big size. We will explain the company why you don't need to file a POM labor and I-140 application again. That's a waste of energy for the company, waste of energy for the government, waste of energy for you, and I think so it's a pure cheating by the immigration authorities.
All right, I think that covers our topics for today, so we will take questions. Real Madrid says, my H-1B extension has been pending for over 4 months. What's the expected time frame from the Texas Service Center? I think when I looked it up today, it was 2 months is normal processing time. So your employer should be able to, nowadays on the USCIS website, when you look up the processing time, scroll down and you're able to put in the received date, and then click a little button and it will tell you what the inquiry date is. That means the case is outside normal processing time, and that means that the company or their attorney can actually put an inquiry in. The easiest way to do that is through the e-request system online rather than calling customer service. But that is a good option if it sounds like 4 months is beyond the normal processing time. But again, only the employer or the attorney can do that follow-up.
Satish is asking a good question. He wants to consider himself to be EB1 qualified. Who is the perfect person in our office to contact? The perfect person is Juanita. It's spelled as Juanita. Juanita Diwar. She is the perfect person for EB1A. Try not to contact me. Try not to contact Emily. She's the one who's designated, and she does a very good job in EB1. She has a very good success rate in our office on the EB1s. Thrush Vaishnav has this question. Any risk in doing automatic revalidation to visit Canada for activating PR? PR is permanent resident, and return to the US. Absolutely no risk. If your I-94 is valid, you are going to Canada, you are going to get a PR there while coming back, and I'm assuming you're going to come back within 30 days. You have no problem in coming back. You don't need to have a passport visa to come back into the United States after your less than 30 days of Canada visit.
Naresh Kumar says, can I work on EAD on a contract with employer B while I have my 485 and H-1B with employer A? So technically, yes, when you have an EAD, you can work for multiple companies. And especially as long as you're still working for the company that supports your 485, you can work for another company on the side, whether that's a contract position, temporary, W-2, 1099, anything like that is fine. But do be aware that once you use your EAD to work for company B, you're no longer on H-1B with company A. You can't be on H-1B and EAD at the same time. It's one or the other. So once you start working for a company that you don't have an H-1B with, you're now using the EAD, and your status is the pending 485, not H-1B status.
SK is asking a question. What kind of status violations can be cleared by automatic revalidation? It's a very lengthy question. I would rather want to know what kind of thing you are thinking in mind. There are a laundry list of things that can be cleared. But I would say that if there is any time a status violation, though, don't take the things in your hand. Have a private consultation with a lawyer and then do the automatic revalidation. For example, if the person he's going for a PR to Canada and there's no status violation there, it's completely clear. Let's say, for example, if the H4 person has been worked without an EAD, that person may have an issue when they are going to automatic revalidation. I want them to consult a lawyer before they go, because there are things that they need to be taken care of. The question comes is that what if the person can travel while the H4 EAD extension is pending? Here is the thing. If it is only the H4 EAD extension that is pending, it's not a problem for you to travel. If it is transferred to the H4, that means let's say you are from H1 or F1, you're transferring to H4 And on top of it, you're filing an EAD. When you are applying for a change of status to H4 plus EAD, when you travel, the H4 will be denied, so EAD will be denied. But if it is an extension of EAD, then it's not a problem when you travel. You'll be fine. You will not have any problem.
Let's see here. Deviana says, what is the duration someone can work from India if they're on H-1B? If the employer is allowing it and they're paying me in the US, even though my employer does not have an office in India. So there is no limit on that, because when you're outside the US, you're not on H-1B. You are, if you're an Indian citizen, you can live and work in India without any kind of US immigration laws being applied to you. So if your employer is allowing it and they're paying you in the US, that's fine. You are sitting in India, you are subject to the laws of India, and US immigration law does not apply to that. So if you have your H-1B valid for 3 years and you work in India for 2 years, you can come back on the remaining year of your H-1B, as long as you have the valid visa stamp and the US job is still available to you. And then you can recapture those 2 years that you spent in India to extend your H-1B further beyond the 6-year limit.
Rohit has an interesting question. I'm in USA on H4. Is it necessary for me to be in USA when the H-1B lottery is conducted next year? I'm assuming that you would apply in the H-1B lottery. No, it's not necessary for you to be in US at the time when the lottery has been conducted. Now, the next question that should come is that, do you need to be there at the time when you file for the H-1B? That is a magical question, though. If you're applying for a change of status, that means that you want to get a H-1B in United States, you have to be here at the time when you apply for not once you're selected in the lottery, you have to apply for the H-1B. That's the second step. If you're applying for a change of status, you have to be here not only at the time of filing, but until the time it's been approved and until October 1st. Both have to be met. You have to be in the country. Now, if you don't care about change of status, you just want the H-1B to be approved and then you're going to get the stamping in India, then you're fine. You can be in India too. But as a strategic point, what I suggest people is to always apply for a change of status because of a lot of different reasons. So at that point of time, you have to be there, but not at the time you're getting selected in the lottery. You can be anywhere in the world at that time.
AJ says, is the GCEAD by itself, without the AP, enough to verify both work authorization and lawful status? Yes, it is. So this is important for I-9 purposes. When you join a new company, they will have you fill out the I-9 and you have to provide proof of your identity as well as your work authorization and lawful status. So the EAD card is a List A document. That means it's a document that confirms both your identity and your work authorization.
Hemendra Sharma, my wife is an H4 EAD, is using our joint brokerage account for day trading. I'm the primary account holder and my wife is a secondary. Will this impact the GC process? No, it does not. We have not seen trading that is online trading where you sell and buy the stocks. That is not considered as working. That is considered as it's not considered as working. So she's fine, not a problem. Those people who want to trade the stocks, I'm not a financial advisor, guys. I'm just advising on the immigration. You can legally do so in immigration law, not a problem. Never been a problem.
Venkata recently joined a new company using the GCEAD, and now they're filing the H-1B petition requesting consular processing. And he wants to know, he's got the unexpired visa stamp from the previous employer's H-1B. Can he use that stamp with the approved petition for the new employer at the port of entry? Yes, you can do that. Just make sure you also have an AP, because you do need the AP to leave the country without abandoning your 485 since you're no longer on H-1B right now. But yes, you can use the old employer's valid visa stamp with your new employer's H-1B approval notice.
Pavan Kumar, does the Department of State release visa numbers to of the adjustment of ASC monthly? I mean, the visa numbers monthly. I'm assuming that the adjustment of status pending cases. No, they don't release it. They only release it. every quarter. And the problem is they always release 3 or 4 months after the quarter is over. There are some times, because of the lot of pressure that we put it on the USCIS last time and the Department of State last time, they started releasing it almost in their in the website. Other than the normal release, they started releasing every 15 days, and probably it's because of the pressure we put it, but it's also because of the court case that has been filed against them. But in general, it's quarterly.
It says Company A acquired Company B 100%, but they're saying that we need to file a transfer because an amendment is not an option because Company A didn't take the responsibility of immigration during the acquisition. What options do we have? Yeah, that is correct. So there are rules that allow a successor in interest to basically take over the employees without the need of filing an H-1B transfer or even an amendment. And just continue the H-1B status under the new company as long as it qualifies as a successor in interest. But to qualify as a successor in interest, the new company does have to take on the immigration liabilities. They have to put a document in their public access file confirming which LCAs they're taking responsibility for. So if they're not doing that, that means they don't qualify as a successor in interest, and a transfer has to be filed instead. And if they've filed any labor certification or I-140 by the old company, the new company has to start that process over for everyone that's moving over to the new company.
Can the H-1B person start working for Company B while he has served notice to Company A that he's leaving Company A? So he applied for the transfer and he's wanting to move to Company B. Now, you cannot work for two companies at the same time unless the second company has filed as a concurrently filed H-1B. So you can have an unemployment period, that 60 days unemployment period is allowed, but you cannot for both the companies at the same time. Senthil has this question. How many EB-1 visas are available for fiscal year 2023 for the entire world, and what is the world demand, please? We have no idea. We will get the quarterly release of the employment numbers probably in March of 2023. That will be only until December 31st of 2022. That will come in March. So we won't get that information until later period of time.
SD wants to know if it's advisable to file both the I-140 in premium and the 485 concurrently based on the current processing times. His priority date is current in December in EB3. Or should he file the I-140 in premium first and then file the 485? You may want to wait until you see the January visa bulletin come out in mid-December, and then assuming that your EB3 continues to be current in January, then you would have enough time to file the I-140 in premium, get it approved, and then turn around and file the 485 even into January in case it takes longer. So that may be an option for you. Processing times have improved. Of course, they're taking a long time on the 485 because they have the whole year to process them when the date is current. And we still, the I-140 and 485 still, when they're filed together, go to the Texas Service Center. So you want to get out of that with your 485 as quickly as possible. So to do that and file separately may still be a better option.
Palopan Saha. I got my employment-based green card, and after I received my green card, I worked for the company for 4 months. Can I leave the employer without any issues? You can. You can leave the employer without an issue. No problem for your green card, no problem for your citizenship, no problem for anything. You don't have to, next job doesn't have to be in the same field. You can work as flipping a burger in McDonald's, you can be a Microsoft CEO, you can be a lawyer like me, or you just sit idle, do nothing, and sit down. That's the beauty of the green card. You can do any of those things. Not a problem for in your green card or getting citizenship.
Raghav says his I-140 is approved with a priority date of 2018. If I want to move back to India for 5 years with a different company, what are my options? Will my priority date still be locked and valid? So yeah, that's kind of what we were talking about earlier. Once your I-140 is approved and you've waited 6 months, you could leave the country and work outside the US for 5 years, 6 years, 10 years, basically until your final action date becomes current, you're eligible in the future to come back on H-1B with a 3-year approval with any employer based on the fact that you have that I-140 approved, and you don't have to go through the lottery again. So you just need to keep your eye on that visa bulletin and make sure that before your final action date becomes current, if you're wanting to take advantage of this 2018 priority date and actually receive the green card, you need to have enough time to have the new employer file the H-1B, consular processing. You can do premium processing, not subject to the lottery. Get that approved, get the visa stamp, come into the US, file the new labor certification, new I-140, port the priority date, and then file the 485 when the date's current.
Ram Par, my I-140 EB1C got approved. I'm not in USA. I'm planning to relocate in January. Already have H-1B stamping. Can my wife join me just for the filing of the AOS and return back to home country after AOS pending? Yes, the answer is simply yes. One thing, Rampur, I would advise you is that, the priority date of the EB1C may go backlog too. So you need to give importance when you're coming. Your passport is already stamped. So why can't you come in December and file the 485? Who knows what it's going to be in January though? And believe me, there are people who wait for 10 years. And there are people who are listening to this conversation live that have been waiting for the green card for more than a decade. And you got this golden opportunity. Come in December if you can, because we don't know what the priority date is going to be for you in January. Have your wife. Yes, answer to the question is yes, she can join you. I'm assuming that she has a H4 stamping and she can go back and keep traveling for the biometrics and other things. She can do so. Her advanced parole may be rejected. That's okay. Her 485 or the green card process will still continue. But please consider my words very seriously. Try to come back and file the application in December. That may be better. And if I were you, Rampar, what I would do is that I will contact a lawyer right now to do the paperwork, even when you're in India. The day you come in, you can file the 485 application. Don't delay that.
Penny says, I moved to the GC EAD. Do we need to worry about the I-94 expiry date anymore? Do we need to renew that I-94, or does the EAD AP cover it? Right, so once you use the EAD AP, you are basing your status now on the pending 485. So it's your 485 receipt notice that is your proof of status along with the EAD. And you do not need to continue to worry about the I-94 date. You don't need to extend the I-94. There's no way to extend the I-94 based on having a pending 485.
Question that comes from Pramod Yakali from Facebook. Can a person scale his skills and do process in the EB1A? Absolutely. That's one of the main topic that we discussed. Yes, you can scale up. We in the United States expect that you scale up. Maybe you'll be the next Sundar Pichai. Maybe you'll be the next Satya Nadella. We expect you to be. And yes, you can scale up. Even though you're in H-1B right now, you can scale up in the employment base. Yes, we want you to scale up and do apply in EB1A. Yes, you can do it. What I would advise you though, that there are certain things to how to scale up. Which ones are better for getting an EB1A? Which ones are better for the industry? Well, of course, what is better for the industry? How to make better money? We are not the proper persons. Okay, but what we can guide you is which categories, if you would focus on, will get you EB1A better. There are obviously 10 things. You have to get qualified for 3 out of those 10 things. But what you need to try to shoot is 6 out of those things you try to shoot. Then you may get 3 or 4 that will get you the green card in an EB1A. So it may be worth for you to have an advice from an immigration lawyer to see which one will get to EB1A. How to become CEO of the Microsoft or Google or Alphabet? We have no clue. We are not the proper persons for it. But EB1A is probably an immigration lawyer would be a much better guide for you to see how to process it that.
JJ wants to know if you can apply for a green card via a TN visa. Potentially. So The TN visa is not a dual intent visa. It's not like an H-1B. It's not like an L. It's intended that you're only coming temporarily and that you will leave the U.S. at the end of the TN stay. It technically does not allow you to be pursuing a green card while you're on the TN. However, if you time it right and you were born in either Canada or Mexico, then you may be able to make it through the green card process without having to worry about that dual intent issue. But if you were born in India, for example, and then later get Canadian citizenship and are using that to get the TN, that's going to be problematic because it's going to take a long time before your priority date becomes current because it's based on country of birth, not country of citizenship. And you may have difficulty renewing your TN after you've got your I-140 approved.
Rampur says his priority date is 2012, but EB1C I-140 is approved. Well, it's up to you, Ram. I still want you to get the 485 done in December. Believe me, I have my reasons for it.
Gokul says, can we have 1 to 2 weeks of overlap between jobs after an H-1 transfer? No. You cannot work for 2 employers at the same time on H-1B, even if you have 2 approval notices, unless one of them was a concurrent H-1B filing. So no, if it's a transfer, when you join the new company, you have to stop working for the old company.
Mr. Jindal has this question. I got my advance parole approved. Does it mean that I'm going to get the green card, or do I have to wait for the visa numbers to be available? You have to wait for the visa numbers to be available. Advance parole will be approved, EAD will be approved, advance parole extension and EAD extensions will be approved if the priority date is not correct also. Once, when you file it, if the dates are fine, then your EAD and advance parole will be approved even if the dates move back.
Senthil wants to know, unlike H-1 I-140s, L-1A I-140s cannot be used to switch jobs. Is that correct? Unless we have the EAD. Yeah, so the I-140s are not tied to either H-1 or L-1, but I get the point that if you're on an H-1 and you have an approved I-140 in EB-2 or EB-3, you can use that approved I-140 to change jobs and keep getting the extensions beyond the 6-year limit. But for an L-1, having that approved I-140, if you're still in L1, you can only work for the L1 employer. You would have to convert to an H-1B to be able to work elsewhere, which means you have to go through the H-1B lottery, unless you get the EAD based on the 485 from that EB1 I-140.
Sri Krishna has this question. I got a second job. Do you suggest me to go on EAD right now? My EAD is approved, AP is still pending. Since AOS is pending from 8 months. I have an H-1B from my first employer. Please suggest. Sri Krishna, I would definitely, I will not tell you what to do. I will tell you what I would do, what I have done. I would definitely use the EAD to the second job. We don't know when the priority date is going to be current. Even if it's current, what's wrong in you working for 2 jobs? We want you to pay more taxes. We want those money. And if you make more money, you're going to pay more taxes to us. Yes, do the 2 jobs. And believe me, when I had an EAD, okay, I have used it myself. I was an immigration lawyer on an EAD. I used it. So that should get you an answer what you should do, but what you should do. I mean, what happens to the first employer? It doesn't matter what happens. You do 2 jobs. If you're doing 2 jobs, you don't have to do anything. Your 485 is continuing and you can be on EAD with the second company.
Ravindra says, I have an EB2 and an EB3 EAD and AP. Which one to extend? And I think a lot of people are asking, can I use one EAD to work for one company and a different EAD to work for the other company and all that sort of thing? So I think it kind of depends. Let's assume that you have, let me say this. The ability to extend the EAD and AP is based on the fact that you have a pending 485. So you need to choose a 485 and you use that one to extend the EAD or AP. So it doesn't really matter one way or another. Could you do both? I suppose. I think you'd be wasting government resources at that point. But as long as you have a pending 485, you can pick which one you want to use to extend the EAD and AP. Using different ones to work for different companies, they're not really tied to anything. When you're just showing it to the company to prove you have work authorization, but that's not really, I don't think it's relevant to anything else.
This question comes out very many times for me. Which EAD should I use? It doesn't matter, guys. I mean, who is asking this question to you, that which EAD you're using? You can show one EAD to the employer, and when it comes to the immigration, they never ask the question, did you use the EB2 EAD or EB3 EAD? Nobody asks the question. You don't have to answer the question to anybody. When a time comes to answer the question, we'll do it at that time. Unnecessarily, don't poke into that, which one, it won't matter for you.
Poonam says, if the primary applicant uses their EAD and the spouse has their own H1, does it mean that the dependent is also using the EAD? No, it doesn't. In that situation, since the spouse's non-immigrant status is not tied to the main applicant, the spouse can continue on the H1 even if the main applicant switches to the EAD. It would be different if the spouse was on H4. Then if the main applicant stops being in H1B status and starts using the EAD, the H4 stops and the spouse has to use the EAD.
Question that we got an RFE that prior date is not current. Is there a chance to get the GC? That's the same Poonam is asking a question. If the prior date is not current, I don't know why you got an RFE for it though, but yeah, they're not going to issue the green card for you if the prior date is not current.
Gunnison wants to know if there's any update on visa stamping inside the U.S. from the administration. No updates. I would not expect this to happen anytime soon. It could be 10 years before they actually do it, if they ever do it. From the things that they're saying about it, they're claiming they've got so many things from an infrastructure standpoint to set up that they just couldn't possibly do it right now. That's them dragging their feet. They don't have any real motivation, I don't think, to get that done anytime quickly, so I would not expect it in the near future.
Pramod is asking a question. I think so. We probably need to address this in a 20-minute video on an EB1, EB1, all different criteria for the people who are on EB2 and EB3. He's asking question, doing a PhD, does it help me in getting the EB1 process?
I think it would depend on the PhD. If you're talking about a PhD from Campbellsville, maybe not.
Yeah, if you are speaking about something in biochemistry and you're doing it, there are two different criteria, guys, for the PhD kind of people. One is called EB1A and EB1C. EB1A, typically, PhD could help to an extent. EB1B, definitely, it is designed for PhDs. EB1B, but not only that you must have the PhD though, you must also work in a research field. And the company must file an application saying that and the company should have other people of your caliber, like a PhD caliber. You must also be judging the work of others and the other things. Definitely for EB1B, PhD will be a lot more helpful. For EB1A, it will be a little bit helpful. That's what we can say. For EB1C, it's irrelevant.
Sharad says, do I need to maintain my H1B if I have the EAD and my spouse is on H4, but the priority date is not current and the marriage happened after receiving the EAD? So I'm assuming this means that after you got married, your H4 spouse has not yet been able to file the 485 because your priority date has not become current again based on the timing of the marriage. So in that case, as long as your spouse needs to be able to stay on H4 till your priority date becomes current again so that the spouse can file the 485. That means you have to stay on H1B until that point, unless your spouse is able to get their own status by converting to their own H1 or their own F1 or something like that. So as long as the spouse has to be on H4, you do have to stay on H1B until your spouse can file the 485.
I mean, this question is coming a little bit it's unnerving question for a lot of people, and I want you to also involve in the question that came from Suren. Have you seen any green cards getting rescinded? That means taken back, the ones that got approved. Um, that got approved. Have you seen anything recently?
No,
No,
no.
no. We have not seen any. Where people have prior date not current, and then they use the previous company's I-140 approval to get the green cards. Have you seen any green cards? We have not seen. We have not seen. And this is, there are some rumors flying around outside the world where, oh, they are canceling all the green cards that have been given. No, we have not seen it. And if we see it, I mean, we will, and if somebody just tells it, we won't believe it. We want to speak with that person. Not if they just make a statement in the chat here, we will go to that person, we'll ask the person, we will speak with that person and get that information. And then we'll relay it for you so that you are informed. We have not seen any green cards getting canceled, guys.
Sycut says, I changed my employer. I have the visa stamp with the previous employer until December 23rd. My previous employer revoked that petition. Can I travel and return with the new employer's petition and the previous valid visa? Yes, I'm assuming you mean the employer withdrew the H-1B petition because you left the company, which they're required to do. So yes, you can still use that visa until it expires, even with that withdrawal. No problem there at all.
Ganeshan is asking a very interesting question that comes out very frequently, is that if I move to India and prior to date becomes current, can I self-sponsor my GC through consular processing? Assuming that you're an EB2 or EB3, the answer is simply no, you cannot. It has to be done only by the employer. It cannot be done by you. Your employer's blessings, cooperation, and approval, and he has to do it. You cannot do the self-sponsorship. You cannot convert into consular processing. You cannot get the green card unless your employer wants to do it. Can I continue work on an unexpired I-94 and expired H-4 EAD, a proof of US mailing, or should I not work while I get a receipt notice? You have to wait until the receipt notice comes in. Unfortunately, they don't accept for the I-9 verification. Is FedEx allowed, Emily?
Not for the automatic EAD.
540-day rule. It's not allowed. Anything else, Emily?
I guess so. We're out of time for today. Thanks so much for joining us. As usual, we will be back next Tuesday. If you don't subscribe to our newsletter, make sure you go to our website, rnlawgroup.com, and subscribe to that. We do send it out every Wednesday with all of the latest updates and articles that you will find helpful.
Don't forget that we do have a daily free conference call. If you go to rnlawgroup.com, you can go to free conference call every single day. Half an hour, we do answer. It's free. It's come. You can ask the questions there, and it will be more interactive. It's be on the Zoom call, and then we will be interacting. We may ask more questions to clarify what your question is and answer those questions daily, half an hour.